All rise. The Court of Appeals, Division 1, is now in session.
Please be seated. We're here today in our case 1 CV16-0252, CONKLIN versus MEDTRONIC. Each side will have 20 minutes to present their argument. Opponent, you may reserve any portion of the time for rebuttal, but you have to keep track of the time yourself. That's why we have a clock at the podium. We are recording the argument, and in a few days the argument should appear on the Court of Appeals YouTube channel. So if you want to relive and rewatch your argument, you can do that. Because we're recording the argument, though, we'd appreciate it if you would identify yourself and your client so that we can keep everything straight when we review things afterward. We've read the briefs and the record, and we've conferenced the case, so we're familiar with the record and the argument. So when you begin the argument, just launch right into what you would like for us to know and talk about. Counsel, you may begin.
Thank you. May it please the Court. My name is Jonathan Osteen. Also present is Paul Friedman. We represent the appellants, Raymond and Joanne Conklin. MEDTRONIC tries to stretch the U.S. Supreme Court's decisions on federal preemption to medical devices beyond boundaries that were ever contemplated by the court. Medical device manufacturers who subject their Class 3 devices to pre-market approval, as was applicable with this device, are protected from civil liability so long as they comply with federal law. As recognized by the Seventh Circuit Court of Appeals in Bausch v. Stryker, that protection does not apply where the plaintiff can prove that she was harmed by a medical device maker's violation of federal law. The MEDTRONIC SynchroMed 2 pain pump that is the subject of these claims has a colorful history. It dates back to August 29, 2008, when the FDA warned MEDTRONIC that the device was alterated in violation of current good manufacturing practice requirements. This is a violation of the pre-market approval that the FDA had given to MEDTRONIC with respect to this device. An adulterated device is one that is not in conformity with applicable requirements or conditions.
But we don't want to resolve the issue in state court, do we?
In terms of whether or not the case is properly pled, then that is an issue that should be addressed in state court, because the violations of these FDA regulations are the underlying basis of the plaintiff's claims in this matter. And that is why these cases are not preempted, because they are based on violations of federal regulations. It's equivalent to a negligence per se argument in a motor vehicle collision. You have statutes regarding speed or proper position of turning. In violation of those statutes is evidence of negligence. That's the same with respect to medical devices. Their violation, for instance, of the good manufacturing practice requirements is evidence of negligence. Their failure to report adverse events to the FDA as required by law is violation and further evidence of their negligence. The violations continued beyond August 2006. In fact, those violations were never even corrected. A subsequent warning letter in June 1st of 2009 concluded that the device was misbranded and that they had failed to establish and maintain process control procedures, and had identified that the problems previously addressed in the 2006 letter were never corrected.
And are all these allegations, this is what's rolled into your failure to warn claim?
That's correct. And some of these allegations are also rolled into our strict liability design defect claim, because the violations of the Current Good Manufacturing Practice Requirements Act is evidence of negligence for a design defect, because the mechanisms with which these devices were manufactured did not comply with the FDA's approval for those devices. In fact, skipping ahead, several warning letters.
Wouldn't you end up by, if you succeeded, wouldn't you end up saying as a matter of state law that the FDA's procedures, approval procedures were inadequate? And if that's the case, how can we have that?
Yeah, that's not our argument that the procedures with respect to approval of this device were inadequate, because that type of claim would in fact be preempted by the medical device amendments. What we're claiming is that their failure to comply with the FDA regulations regarding the approval of this device is what gives basis to the strict products liability claims as well as the negligence claims, and those claims are not preempted. And
correct me if I misunderstand, but if the device has passed FDA approval, how can it be defective?
well, it's defective based on manufacturing defects, not with respect to the design that was approved by the FDA, but the way that they implemented those processes for creating the device, for manufacturing the device. And that issue is addressed in the Regal case, which is a U.S. Supreme Court case. It's Regal v. Medtronic. And the court in that case held that if the problem is a failure to comply with the FDA's legally enforceable conditions for approval of the device, the manufacturer is not protected by 360K. The reason that exists is because that claim parallels their federal requirements. We're not imposing additional requirements on Medtronic when we say that their manufacturing of this particular device was defective. We're doing exactly what they were obligated to do as a condition of marketing and producing this device pursuant to the FDA regulations. And we know that that's important in this particular case because on June 3rd, 2013, which is 3 months after the events that give rise to this litigation, the FDA issued a Class 1 recall. That is the most serious recall that the FDA can initiate. It means that there's a serious risk of death or serious bodily injury in connection with a device. And the reason that the device was recalled on June 3rd, 2013 is that patients may receive drugs from the pain pump unintentionally at a much higher rate of infusion than should have been provided. And that parallels, that goes with respect to Mr. Conklin's experience in this case. He was in Banner Estrella Medical Center, and on March 2nd, 2013, he suffered an acute respiratory failure. Dr. Niranjan Banda, who's a physician at Banner Estrella Medical Center, actually concluded that it was most probably caused by the Medtronic pain pump. As a result of that experience, after he was resuscitated, they put a magnet on the pain pump to temporarily deactivate it so it would stop providing this pain medication to Mr. Conklin. 2 days later, on March 4th, 2013, they decided to remove that magnet so the device would again be permitted to operate. And again, he was found in an altered mental status. As a result, now he has permanent short-term memory loss. And a different doctor at Banner Estrella Medical Center, Dr. Punaya Morella, suspected a problem with the pain pump's function. It's exactly what happened with respect to, it's exactly why this device was recalled by the FDA. And the trial court, as well as Medtronic, have urged a causation analysis in terms of whether or not anything with respect to the manufacture of the device or anything with respect to adverse warnings caused these particular injuries, whether they could have been avoided had the FDA been properly warned, and as a result, physicians or patients learn of those warnings. And at this stage in the litigation, it would be inappropriate to get involved in a causation analysis. Arizona is a notice pleading state, and we have alleged with respect to the conduct and the acts and omissions of Medtronic as a result of this device that Mr. Conklin was harmed. That harm is reflected in his medical records as confirmed by doctors who suspected that the pain pump had failed. At this stage in the litigation, it is difficult for a plaintiff to get more information and speak with more particularity regarding causation and how the device failed in this particular instance. It's because many of the documents that are relevant to this are confidential. We do not have access to them. We will only have access to them in the context of discovery. Beyond confidential materials possessed by Medtronic or possessed by the FDA, we're also limited in our ability to do discovery with the relevant medical providers, many of whom are defendants in this underlying case. We can't just go out and speak with them. Discovery has been stayed pending this appeal, so no depositions of these experts have been taken. So at this pleading stage, it would be very difficult for us to give more specificity with respect to causation other than the fact that he experienced these episodes. They're consistent with problems that the FDA had recognized, and two of his doctors had attributed those symptoms to a failure of the device. As a fallback measure, and before I get there, I really do want to address the importance of the Stengel v. Medtronic case, because I think that's the most important case that this court will consider when it's deciding its ruling in this case. It also involved...
And doesn't that primarily pertain to your failure to warn claim?
It does. It does primarily reflect the failure to warn claim, which is a negligence-based claim. And the reason that it's so important is that it also involved a Medtronic pain pump. It also involved application of Arizona law. It was an 11-0 decision by the Ninth Circuit Court of Appeals. And as this court has pointed out in Fiore v. College and Corporation, Arizona courts customarily find the Ninth Circuit authority to be persuasive on a federal question. Some of the cases that Medtronic has cited in opposition are district court level cases from the Western District of Kentucky or the Eastern District of Pennsylvania. This was a unanimous 11-0 decision from the Ninth Circuit Court of Appeals that held that the failure to warn claim was not preempted because Medtronic breached its duty of reasonable care by failing to report to the FDA adverse events associated with the device. We made the same allegations in our complaint. They're supported by FDA warning letters on multiple occasions where Medtronic had failed to advise the FDA of adverse events. As a fallback position, the trial court also looked to comment K of the section 402 of the restatement second of torts. That restatement would apply to strict liability claims. It wouldn't apply to our negligence claims against Medtronic. But if it were applicable, it would apply to a strict liability claim, which I believe is count 2 in our complaint. It does not apply, though, in this case because by its wording, it applies to unavoidably unsafe products and specifically uses as an example new or experimental drugs for which there can be no assurance of safety due to lack of time and opportunity for medical experience. In Gaston v. Hunter, this court addressed comment K with respect to a pharmaceutical, which was a new and experimental drug. And that court said that as long as the manufacturer clearly advises that a drug is experimental and warns of known risks, then it is absolved of liability under strict products liability. That's not the case here. Medtronic might have an issue with its lawyers considering this device as unavoidably safe, unavoidably unsafe, which is a prerequisite to application of comment B. Further, the bar on strict liability in comment K applies only when the product is properly prepared and marketed and proper warning is given. That falls right back to our failure to warn claims in that they weren't reporting adverse events, that there were problems as documented by the FDA with respect to the manufacturing protocols of the device. And finally, it was recalled as a result of defects in the device that bear directly to the issue that Mr. Conklin suffered. So I would urge the court to remand this case to the trial court, find that the claims as asserted against Medtronic do not conflict with federal regulations, so there is no basis for them to be expressly or impliedly preempted. And I see that I have 5 minutes, and I would like to reserve that time for a rebuttal.
Sure, that's helpful.
Thank you.
Good morning. May it please the court. I am Mike McCarthy, and I represent the Medtronic appellees. The Superior Court correctly found that plaintiffs' claims are preempted, and that is because, and also that in other respects they fail to state a claim, and that is because the device at issue, the Synchromed infusion system, is one of the small category of devices that receives pre-market approval from the FDA. It's a Class 3 medical device. And it's one of the small category that, as a result of the regulatory environment, which applies both to pre-market and post-market, the Congress has decided that these devices will not be subject to state tort law in almost all respects. The only exception being the so-called parallel state claim, which I'll address in a few minutes, but which has not been adequately alleged here. Why did Congress do this? Congress, according to Regal, the Supreme Court in Regal, Congress did so because it made a determination that it was better to protect innovation with respect to this small category of devices, and that innovation would be discouraged by applying 50 states' tort laws to the manufacture, design, and labeling of Class 3 medical devices that have gone through the pre-market approval process. The pre-market approval, contrary to the implication perhaps of the statement about the colorful history of the device, pre-market approval remains in place. It has not been withdrawn. It applied to Mr. Conklin's device from the time it was implanted through the time of the events that when he alleges that he was overdosed. And I'll pause briefly on his allegations about what happened because his description, his counsel's description just now didn't fully capture what's in the complaint. What happened, as described by the complaint, is that when he was in the hospital, there was a concern that he was receiving an overdose, and it was resolved, when the second physician realized that they had not reduced the dose on the pump as they were giving him other pain medication when he was in the hospital. And that's clearly alleged in the complaint. So this is not a case where there's any sort of obvious indication that anything happened with the device.
Isn't this a strange preemption scheme that it's not preempted if it's a parallel claim that I take it, and correct me if I'm wrong, that it has the same elements, it doesn't add anything, then the state claim can proceed?
It is correct that so-called parallel state claims can proceed, and what those claims would be are claims, in effect, that the manufacturer did not follow the FDA requirements. So if this device had been manufactured using a different metal than the approved metal, or in a different shape, or if it had been labeled in a different way, that would be a claim that could be asserted. There still need to be a causal connexus.
But I mean, how about failing to report post-approval adverse events, as is alleged here?
Two things about that, Your Honor. It is true that the Stengel court found that claim would not be preempted. I think the Stengel court is mistaken in that judgment. But Stengel is also distinguishable, as the Superior Court found here, because in Stengel, and I'll come back to why Stengel, I think, is wrongly decided, understanding it won't surprise the court that Medtronic, being the losing party to that case, thinks it was wrongly decided. And other circuit courts have found contrary to the Stengel, to the Ninth Circuit in Stengel. But the allegations there, and this, I'm looking to the panel opinion now, because there was a panel opinion and then it went en banc. And the panel opinion says the Stengels alleged that if Medtronic had complied with the regulations, Medtronic would have warned physicians about the newly discovered danger that the pump might cause inflammation, which would have allowed a quicker diagnosis of Stengel's symptoms and prevented his paralysis. So the issue there had to do with the tip of the catheter, and the allegation was that Medtronic learned some things that it should have told the FDA about, and that there would have been a warning, and that is exactly what happened, so it was alleged to Stengel. Here we don't have any such allegation. What we have are allegations of a colorful history, as to use the words of plaintiff's counsel, and there's no connection to what happened when he was in the hospital. The closest he comes is this suggestion about the June 2013 notice, which was in fact a notice that came out from Medtronic about overdosing. But what he fails to allege, a couple things about that. One is when he describes his parallel state claim in his opening brief, and this is page 24, he does say it's only about failure to warn. It's not about anything else. So his argument this morning suggested there were other parallel claims, but that's the only claim that was advanced in the opening brief. But the claim that he's making about the overdosing, as alleged in the complaint, relates to something called priming the bolus. And there is no reference to that in his opening brief. It is in the litany of things that he says that he describes as this colorful history. He doesn't actually refer to that procedure, and it's not surprising because he has no allegation that procedure was done when he was in the hospital. And he has fairly detailed allegations about what happened when he was in the hospital, and it does not include that. Now, his other allegations about the colorful history include things that clearly are not relevant or that were warned about prior to the event that he's complaining about. So he's complaining about 2013, and he's noting warnings that occurred prior to the time that he was hospitalized, for example, related to the use of unapproved drugs. A few things about that results in underdosing, not overdosing, and it was warned about. And the principal problem, the principal reason all of this is preempted is that, and why Stengel is wrong in our judgment, is that the requirement is that Arizona have a state law requirement that would exist if the FDCA, the Food, Drug, and Cosmetics Act, was not there. And it's impossible to look at Arizona law, contrary to what Stengel holds, and say Arizona required manufacturers to file reports with the FDA. Now, Arizona clearly has a duty to warn, no dispute about that, but that duty to warn is not a duty to make reports to the FDA. That is a duty to warn, in this case, physicians. And that's the learned intermediary doctrine, which the Supreme Court, the Arizona Supreme Court addressed last year, I think it was, in Watts. And what it held, that doctrine provides, is not about, it doesn't refer to providing reports to an agency or a third party. It says you provide reports, or you provide warnings to prescribing and other healthcare providers who are in a position to reduce the risks of harm in accordance with the instructions or warnings. And there I'm quoting from the restatement provision that the court adopted in Watts.
If Medtronic had, and I understand this is disputed, but if Medtronic had made all of the reports regarding adverse events, would that have affected the physician's actions in choosing to use the pump?
Well, not so far as we can tell from the allegations. And that's essentially the allegation that's missing. There isn't a suggestion that there would have been a warning. Now, they can't say the FDA would have required a warning because that's impliedly preempted under Buckman. And many courts have acknowledged that. You can't say, well, if you had done this warning, then the FDA would have done X. What they're saying is Arizona has to require the reporting to the FDA, and then that sort of on its own finds its way to the physicians, as opposed to a warning being issued from the manufacturer as required by the FDA. And in Stengel, the suggestion was that would have happened because and here there is no such suggestion that there was what the warning is. Our fundamental problem we believe it's preempted, but fundamentally where we get stuck is, what's the warning? What warning should have been made? In Stengel, we know what warning should have been made. It's about inflammation that may result from the tip of the catheter that's inserted into the fluid around the spine. Here, we don't know what warning it is that plaintiffs contend should have been made that would have made any difference. And that's what the Superior Court found. And that's how the Superior Court distinguished Stengel. Now, again, I'll just to preserve the point, we don't think Stengel was rightly decided, but the court could avoid that question as the Superior Court did, and find that the claims are preempted because there isn't any causal nexus between this suggestion that there should have been some unidentified adverse event reports made, or medical device reports that should have been made to the FDA, and that there would have been any kind of warning that would have made any difference to what happened here. And given what's alleged, it's hard to know what that would have been, because at least as alleged, and to be clear, what's been stayed is the medical malpractice claim. That's what's been stayed. That's count one of this complaint. The other counts relate to the device, but count one is medical malpractice, and given what's alleged, it's not surprising, because the allegation is the doctors failed to take account of the medicine he was already receiving from the pump at the time that they provided other medication, and that resulted in adverse effects, as alleged. So there are two types of preemption, as I think my comments have made clear and our briefs make clear. There's express preemption, which says the state court can't require anything, or state law can't require anything that's different from what the FDA requires. And then there's implied preemption, which under Buckman says you also can't be simply asserting, you can't be enforcing the provisions of the FDA regulations without an independent state means of doing so. You can't say, and that's the problem with negligence per se, and why, as we've cited in our brief, many courts have found that negligence per se claims are preempted because you can't say, well, the negligence per se claim would not exist but for the existence of the FDA requirement. And the notion is that it's the conduct of having to report to the FDA that Arizona law would have to have otherwise required. And there is no indication that I've found in Arizona law up to this point that it does have such a requirement of reporting to the FDA, as opposed to providing warnings to physicians, which there's no question that exists. As a small aside about Stengel, to the extent that the learned intermediary law and the warning law was unsettled, because this court will likely recall that it found that learned intermediary was not the law in Arizona. The Arizona Supreme Court then adopted it in Watts, but at the time that Stengel was decided, at least according to this court, there was no learned intermediary doctrine. There was not a report, a means of simply reporting to the FDA, or to physicians, I'm sorry, to satisfy one's obligations. The claims that are asserted against Medtronic are design, manufacturing, warning. There's a negligence, which is basically a post-sale failure to warn, and breach of warranty. And as the Superior Court found, they're all preempted. And the argument's been made that they shouldn't have to plead what this warning is because they don't have the documents. Well, their complaint is fairly detailed about the quote-unquote colorful history, and the reason it's detailed is because all of that information is publicly available. What they've failed to do is connect what happened to Mr. Conklin to any of those publicly available reports about the history of the device. And that's not something they're going to be able to solve by getting discovery. That's something that they have everything they need to be able to do that. And this isn't a case where we're suggesting that there's an unduly stringent pleading requirement. We're simply saying you have to state a claim. This court and the Arizona courts have applied affirmative defenses at the pleading stage. The statute of limitations is probably the most common circumstance where that occurs. And the court says if it appears that the action is untimely, then the burden shifts to the other party to try to explain how it is. Here, there's no question that there's preemption. Plaintiffs are trying to fit within an exception, and they have, other than making conclusory allegations, they have failed to demonstrate how they fit within that exception. They simply say that there is some causal relationship between an unnamed adverse event report that Medtronic failed to make and what happened to Mr. Conklin. And that's in our judgment, that fails to state a claim, and that was the judgment of the trial court. The trial court also found that the warranty claim was preempted because the warranty is that the device was safe and effective, and that the FDA's findings in that regard are controlling. In addition, the trial court found there was a lack of adequate notice that wasn't challenged meaningfully. That it's 2 years that had gone by, and the notice requirement was therefore not satisfied as well. And then there's comment K. Comment K is perhaps to some extent superfluous here because the design and manufacture of the device those claims are expressly preempted, but if they weren't, comment K would apply as the district court found, and it would eliminate the strict liability claim. On the Stengel causation issue, one additional point. Stengel, the en banc court, which went the other way from the panel that I quoted earlier, relied on a couple other circuit court cases, and one of those was the Fifth Circuit case in Hughes, and that also illustrates what's missing here. So in Hughes, the allegation was that the medical device had caused burns, that there was some leaking that occurred. And the allegation was that if adverse events had been reported, there would have been an earlier warning. Now, other courts have said that sort of claim would be preempted as under Buckman, because that's an attempt to enforce the FDA's requirements. But putting that aside, as Stengel did, you there had an allegation that the warning would have come earlier, that the warning about burns, which is what happened to the plaintiff in that case, would have come earlier if the adverse events had been, or if the medical device reports had been submitted to the FDA. Again, we don't have that level of specificity here. We have simply a vague allegation that certain adverse events of unknown origin were not submitted, and that as a result, without any connection, Mr. Conklin was injured. Most of the cases in which this court has applied it has looked to the causal allegation and the adequacy thereof on a motion to dismiss have been unpublished. I'll admit that, and so I'm not going to cite them, except as I understand the court's rules, I can cite a recent one, and there was one from January of 2017, which is not in our briefs, I will acknowledge, called Cutter versus Crown and Shield, number 1 CACV 150780, was issued at the end of January. And there the court, simply as citing it by way of a persuasive example, this court held that allegations about simply something wrong had occurred involving microscopic particles of an unknown nature, and that they had entered the plaintiff's bloodstream and had caused him harm, that those were insufficient. And we respectfully submit the allegations here are equally insufficient. One final point, unless the court has questions regarding the suggestion that the trial court should have allowed an amendment. In the plaintiff's reply brief, they say, well, at a minimum, we should be allowed to amend. The trial court, they did not make a motion in the trial court to amend. They did mention it again, I think there in their reply brief, or in their opposition. They didn't file a motion. They did not file a proposed pleading, which I understand Arizona's Rule 15A4 requires. And they did not mention it in their opening brief. And again, my understanding of Arizona practice is that arguments presented for the first time in the reply brief are waived and may not be considered by this court. And for that, I'm citing Anderson versus Country Life Insurance Company, 866 P. 2nd, 1381. A decision from this court from 1994. So as my time expires, I would ask the court to consider on the so-called parallel failure to warn claim, what warning should Medtronic have given that's connected to these adverse events, assuming that the court accepts that there's a duty, which we don't think there is, but if there is a duty under Arizona state law, what warning should have been made that would have prevented or even plausibly suggested that plaintiff would not have experienced what he experienced when he was hospitalized. Thank you.
Counsel. Counsel Robola?
I just have 6 issues that I want to address from that argument. I want to address the Stengel court decision, causation argument, state law regarding medical devices, the learned intermediary doctrine, breach of warranty claim, as well as our request at the trial court level to be given an opportunity to amend the complaint if the court found deficiencies. Medtronic, not surprisingly, believes that Stengel, the 11-0 decision, was wrongly decided. They had an opportunity to file a petition for cert to the U.S. Supreme Court. In fact, they did that. Although the U.S. Supreme Court denied cert, would not hear the case to overturn Stengel, before that denial, the Solicitor General filed an amicus brief on behalf of the United States. And in that brief, the Solicitor General provided his opinion that these matters are not subject to express preemption. They're not subject to implied preemption. The claims were valid, and the court should not hear the case on certiorari. It also addressed causation arguments, which is a second matter that I wanted to address, and why at this early stage it's a dangerous matter for the court to get involved in a causation analysis. And one of the things to keep in mind is that preemption is an affirmative defense. The plaintiffs are not required to anticipate and plead against any affirmative defenses. We believe we've done that. We believe that the complaint on its face submits a valid claim. But we're not required to plead that. This is a notice pleading state. We've pled duty, breach, causation, and damages. The causal nexus that he referred to, that he believes is difficult for us to prove, it's important to keep in mind that our access to information is very limited, and that is illustrated no better than the fact that in April of 2015, 6 weeks before the before the motion to dismiss was filed, Medtronic and two of its executives entered into a consent decree and accepted responsibility for repeatedly failing to correct violations relating to the manufacture of the Synchromed implantable infusion pain pump system. The consent decree noted issues with manufacturing that resulted in various problems, including over-medication.
But how does all that relate to your client's claim?
Well, our client was over-medicated, and they entered into a consent decree where the FDA found that they violated federal regulations, and at least in part, their violations resulted in the over-medication of people who were implanted with the device. And this fact was not included in the motion to dismiss. We had no idea that they had entered into a consent decree until after the time that the trial court had already ruled on the motion to dismiss. In fact, as part of a motion for reconsideration, several of the defendants joined in our motion for reconsideration based on the fact that this consent decree existed and had not been disclosed by Medtronic in this case. And I certainly don't fault Mr. McCarthy because he wasn't involved in the case back then. But it's surprising that such a impactful document that relates specifically to this device and relates to the allegations that we've made was not provided. And it just illustrates the dangers. Because there's not discovery, we don't know everything about the device that Medtronic does. And it's impossible for us to plead greater specificity when we don't have the access to discovery. Arizona state law has always provided a remedy for injuries from defective medical devices. Failure to warn is based on traditional state common law. And as applied in this case, that common law is that Medtronic had a duty to disclose information regarding adverse effects of their product, and instead they concealed this information. The learned intermediary doctrine is interesting as applied to federal preemption, and it's one that came up in the district court in California in the Coleman v. Medtronic case. You notice a lot of these cases involve Medtronic. In that case, the court held that the duty to warn should not be so narrowly defined as to exclude a requirement to file adverse event reports with the FDA if that is the only available method to warn doctors and consumers. So they recognize this issue with respect to preemption. You can't force Medtronic to warn doctors. You can't force them to warn patients because that would be preempted by federal law. What you can force them to do is warn the FDA.
Counsel, your time is up.
Great. Thank you.
Thank you for your argument. We appreciate your arguments today. We'll take this matter under advisement and issue a decision in due course. If counsel for the next case is here, we're going to stand adjourned, but sit at counsel. Or sit at bench while new counsel comes up. So thank you very much.
Thank you.